So it's Linsey and Sam, and as promised on our Twitter page, Brittany Law Army, we're here to have a discussion about a few things that have been going on in the movement since the last time we had a discussion about things that were going on in the movement. Sam's going to start by talking about the latest accounting documents that came out, and we'll just kind of take it from there.
Sure. So first, I'll just point out behind me is a map of the city of Louisville, which is in the state of Kentucky, where I'm very proud to be from, and Linsey, you as well, I assume, are proud to be from the state as well.
Absolutely.
There's nothing to be ashamed of. It's a great state and a great city. So the 12th accounting was filed, which covers the period from January of 2019 to December of 2019. First off, most notable, just on a glance, is the fact that in the 11th accounting, which covers the year 2018, Britney Spears was worth $59 million. According to the 12th accounting for the year after that, her net worth, or I won't say net worth, her property on hand decreased by a total of $2 million, down to $57 million. Which is interesting because the attorney's fees that Jamie Spears is asking for the court to approve at this point rack up to around $2 million. So it just points out or shows further that this conservatorship is a financial burden on the state of the conservatee, which is Britney Spears here. The other thing to point out is the fact that they spent nearly $1 million more out of Britney's estate to cover legal fees, as opposed to what they spent on the living expenses for Britney Spears. There's a lot of transactions to go through in that. I mean, the accounting report is 121 pages in total. Her living expenses account for a lot of that page count. And the fiduciary fees also account for that. So, I mean, there's a lot to go through. We haven't gone through all of it, but it's just kind of the same racket that we've seen this entire time. Her money is being spent on maintaining this conservatorship and the people that benefit off of it, the attorneys and the business managers and everyone else.
So this is something that you have taken an interest in, I would say, more than I have. Not that I'm not interested in what's going on with the accounting. I'm just saying that you have an attention to detail and an ability to go through mass quantities of paperwork without, wanting to poke your eyes out. But all in all, it is large. 100 and what did you say, 31 pages?
21.
But as far as court documents go and accountings go, that's actually not that big considering how much wealth she should have. Does that make sense?
Absolutely, yeah. I mean, there's a lot to be desired in the pages that they turned over. I mean, for someone of her wealth and her status, you would imagine that an accounting for not just her expenditures over the years, swiping the debit card when she goes to Starbucks or Target, but all the investments that she makes or fiduciaries make on her behalf, all the different business transactions, whether or not she's working. I mean, it doesn't really matter. Her estate is kind of its own gigantic paper tiger that exists and operates regardless of whether or not she's working. I mean, her money is working for her.
Well, it should be. It
should be, yeah.
It should be working for her. And it is one of these things that's kind of like a loophole where, they're submitting an accounting based on the books and the records that they themselves kept. And it's really only a small fraction of what their actual books should look like. So, and I understand that accounting paperwork and probate or conservatorship actions is specific in nature, meaning you're only supposed to be reporting certain statutory things, but I still think 131 pages is really small. I mean, we get motions all the time that are in excess of 150 pages that say way less than, what an accounting should.
Right. It's a small glimpse into what is actually going on. And
Right.
you're right. I mean, we just sent off discovery that the responses alone were over 200 pages. That's not including the production of documents behind those responses. So, I mean,
Exactly.
it's small. It's really small. There's a lot more there that we're not seeing.
And so that's kind of concerning. It's just one of those things that I'm like, okay, well, I don't understand why this is only 131 pages. My expectation would be much more than that. And then the question becomes, what's being omitted? Because of course, nobody has the records, the actual financial records to compare to what the accounting is, because there's never been a contest about what's going on behind the scenes. Maybe when Bessemer actually starts working and has some authority, there will be some discussion about the books versus what's being reported, but I don't know. It's just all so shady. I think the other thing about it that really bothers me is you brought up the fact that her living expenses were less than the amount that she paid in legal fees.
Right.
And there are things that I feel like are not ethical. I mean, we both work, I would say at least 80% of our practice is plaintiff's work, and all 80% of that civil rights cases. Our clients never make less money than us at the end of a case. That's the rule. It's the right thing, and it's actually a rule of professional responsibility. And while I'm not saying that Britney Spears' living expenses account for what she's making, I am saying that her lawyers did not do over $1 million worth of work in the last year. That didn't happen. So I think that should probably be something that's considered later if you're talking about trying to reclaim lost assets or wasted assets in this case.
Right. And there should
other
be
thing-
some sort of ratio there. I mean, just because she's a millionaire doesn't mean that she should be paying more than what she spends on herself or even her state earns in the year, because we don't know what her state's earning.
Well, and that's the thing, is that your lawyer's pay is not contingent on what you make. If I have a client that makes $100,000 a year, they pay the same rate as my client who makes $500,000 a year. And if they had the exact same cases with the exact same facts, guess what? It's going to be the exact same amount. I mean, that in theory is how it should work. So Britney Spears is not the first person in the state of California to be put into a conservatorship. She probably won't be the last. And I guarantee you that Joe Blow from off the street who gets put into a conservatorship's attorneys are not charging him over $1 million a year.
I guarantee you Sam Ingham isn't charging his other clients that he's appointed to represent in their conservatorships nearly the amount that he's charging Britney Spears.
And I'm not an idiot, okay? I understand that Britney Spears has a very vast estate and there are more considerations and more time would be spent in her particular case, given the amount of wealth that she has and her public presence. I mean, marketing and media and messaging, that is a cost that they are paying attorneys for.
Yeah.
So
they're paying attorneys and they're paying business managers. TriStar is a business manager and an entertainment manager. I don't know what's going on with them.
Yeah, TriStar is a joke, is what TriStar is.
You also have Jamie Spears, who, prior to stepping down in September of 2020, 20 or 2019, I got COVID, I don't know what year it is. But before he stepped down from the conservator of the person, he was paid a salary to be conservator of the state and the person. He still has a salary for being conservator of the state. But at the time that he was acting in both roles, he was receiving a salary, and Jody Montgomery basically was brought on so he could farm out his responsibilities to Jody Montgomery. But he didn't pay Jody from the salary that he was already getting for being the conservator of the person.
He
Brittany's
doubled
estate paid Jody. So he got the money and checked out, and Jody started doing his job, and then, you know, something happened and he had to step down. And that's when Jody became the conservator of the person. But she was already making money paid for out of Brittany's estate to do the job that Jamie was being paid for out of the state, which was approved by the court.
It's a classic case of double dipping.
Yeah.
I mean, it's 100% double dipping, and also like a tax write-off, you know? Okay, cool. We're going to pay you, and we're going to pay you, and we're going to pay you. And my best friend, Bob over here, and, you know, Ryan, and all these names that aren't coming to mind, but whatever, you're all going to be paid from this particular account so that we can write it off as loss of income, you know, paid income,
Right.
employee-based income. And no, of course, Jamie's not going to take a hit on his, like, I use the word take a hit, but that is the thing that happened, is that he assaulted her son and then cost her more money in child support. It's like, she can't win in this situation. And I mean, I am like every day dying to actually hear from her, like actually hear from her. Unabridged, open-ended. What do you want? What can we do? I mean, as an attorney, it kills me that we can't actually get that specific information. Like, what do you want us to do? You know, like, we are here for you. Just tell us. But we're not getting that kind of information. It kind of segues, though, into the next topic we were going to discuss tonight, which is interested parties. So on your actual Twitter page, Lawyer Ops, you posted about the California Probate Code, requirements for someone to petition to terminate a conservatorship. And basically, you brought up the fact that an interested party can do that. And why don't you tell us a little bit about what interested parties are, or rather who they are, because they're not objects, and what role they could play in terminating a conservatorship?
Sure. So the term interested party or interested person is actually defined in the California Probate Code. In section 1424 of the Probate Code, it defines an interested person or party as including an interested state, local, or federal entity or agency, a public official, or employee of the state of California, or a local, in this case, Los Angeles public entity, or an entity of the city of Los Angeles, which I just basically said. Sorry, I'm reading my phone.
That's okay.
So I mean, it's broad, but what an interested person party can do is, you know, they can enter into a conservatorship case and make their appearance known and ask to be made aware or updated on different, whatever aspect of the conservatorship or the conservatee's life they want. So if they want medical records, they can ask for that. They have to give justification for why they should get that information. If they want to be kept up to date and informed on, you know, the person, the conservatee, and how they're being managed and what's going on in their life, they can ask for that. And if they want to terminate conservatorship, they can petition and do that.
So the statute reads pretty broad. There are some very specific types or demographic of person that has been defined as an interested party, like a public official, etc. We talked about this a while ago, just, soundboarding off each other, like, what can we do as the public to move this along faster? Like, what needs to happen for us to start getting access, because this is a theme in a lot of cases that even I have lack of access, can't get to something. I mean, me and you had a case where we had to jump through 1,000 trillion billion hoops just to get to a couple things that weren't even that serious. And you know which case I'm talking about. And it ended up
Don't actually.
the one where we had to have the cell phone
Okay, yeah, all right.
forensically
I thought it was
analyzed.
that one. I thought it was that one. Yeah. And
Yeah,
we're up
yeah,
against more delays.
it
Now
was
because
just
of
like
COVID.
everything was a delay. I mean, everything was a delay. Everything was an objection. No, yes, no, yes. Who's paying for this? Who's paying for that? It's like you can fight about these things forever and ever, and things can continue to go on at a never-ending rate. And I just feel like that's kind of what's happening in this case, and that's why a lot of people are frustrated, is that it is actually just being drug on and on and on and on and on and on. I mean,
Yeah, in this case that you're talking about, I'm not going to give away any details, honestly, but we've joked that in this case there are 3 different law offices, 2 law firms, but 3 different offices.
in 3 different time zones.
And yeah, in 3 different time zones. And at one point I was convinced that.
And all on the defense.
Yeah.
That's not even us,
It's everyone coming at us.
We are 2 different law offices.
So at one point I was convinced that one of these firms was hired for the sole purpose of sending us harassment demand, discovery demand letters. Because it was constant, like every week to 2 weeks, we would get a letter about how our discovery was deficient. No meet and confer offer, just, hey, you need to give us this. You didn't give us this. Explain this. And we responded because that's what we do. We respond and we're confident in the answers we give. But this, it got to the point where we had to go in front of the judge and argue over a broken cell phone that was turned over, and it was.
Well, and the point is that it was very clear to us very early on that these particular defendants did every single possible thing that they could to try to get this case dismissed procedurally.
Oh, yeah.
They started with process, and then they moved to legal deficiencies or jurisdictional issues. And the truth of the matter is they got beat, they got beat, they got beat, they got beat.
4 times.
I mean, they tried it.
With two different judges.
2 different judges. There's a change in the guard in between, the time this case started in 2017 and today. So it is just a thing that can happen. And we believe in this particular case, they became harassive after the second or third kick in the pants because they knew that they had no other option. There's a saying in law school, if you don't have the facts going in your favor, you look to the process. If you don't have a process issue, you literally kick and scream and beat your fists on a table to be the loudest person in the room. That's what they were doing, because we have a trial in this case in June, which is why it's on my mind right now, but they're going to lose. I mean, they are going to lose really, 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 really bad. And I'm going to enjoy it a lot because they deserve it. That's
unless they settle at mediation.
Yeah, well, I mean, I don't think either of us think that that's like a real possibility. But my point is that drawing from our own experiences, we understand things can go on way longer than they should. In this particular case, though, there have been so many public overtures. I don't understand how they're still dragging their feet and collecting a paycheck. I really don't understand, especially after Jamie assaulted Brittany's son. At that point, like overhaul. Everybody on Team Jamie, take a step back, because it's not safe here, there, or anywhere. Like, you don't need to be touching her books. Thank you for stepping away from her son, also costing her more money in child support, but you shouldn't be here. I mean, I think that's pretty basic. And I think that if it had been our case, that's how we would have run it. If we were
Right, well,
really,
we certainly would have made the court informed of the fact that this is the reason he's stepping down and the reason he shouldn't be involved in anything, because, like, I mean, stepping down from the conservative the person doesn't really uh, vacate his ability to influence Brittany's life. I mean, there's plenty of examples of emotional abuse purely on the control of money, which is what he has right now.
controlling the purse strings is like one of the oldest tricks in the book for submission.
Yeah.
I mean, if you control all access to money, then what is somebody who has no human rights going to do to survive? I mean, they're going to do what you tell them to do. So I think it's been an issue for a while. And it brings me full circle back to the discussion on interested parties that we're having right now. We're all dying to do something. Can the public do it, Sam? Can we become an interested party? Can we band together, hire an attorney, make an argument that as a public person of interest, Britney Spears is sharing and has shared enough of her life with us to actually make us interested in the eyes of the law to become involved in this process?
It's a very broad question.
Well, I mean, in this soundboard, me and you talked about this and we said, I
Right.
don't know, maybe,
No, in
I'm-
theory, we could, and I mean, it'd be really an interesting and novel issue that would delay what's going on already, because it would go up to the California Supreme Court, because there's never been a conservatorship like this. I mean, there's never been someone at her level of fame with, millions of fans around the world that can plausibly say that we feel like we're interested in her life and are concerned about her health and well-being. That's never happened.
There was the guy from the B-52s.
Right.
At the time he was put in his conservatorship, he was extremely popular, top of his career. I mean, peaking out. And it was a family money thing. And ultimately speaking, his girlfriend / wife, she was his girlfriend when he got into the conservatorship, was his wife by the time he got out. She petitioned to have it terminated. But there wasn't access to social media platforms. There wasn't access to internet or videos or, the reason this movement got started was because people were tracking her. Like, what's going on with Britney? What's happening today? Oh,
why did she disappear? Where'd she go?
Where'd she go? Why is she posting with these weird emojis? Like, why didn't she use an emoji? Why is she using
emoticons?
Exactly.
She's
like
never used before.
I mean, that's some Sherlock Holmes stuff right there. I mean, seriously, it is.
That's what we're good for. And that's how we can. I mean, that's our only avenue, I think, is just to put pressure. We can't directly file a petition to terminate as an interested party, but we can pressure the people who can. Well, I don't want to put pressure on her family, but her boyfriend, domestic partner, he's been with her for 5 years. I think he has standing. I mean, I have no doubt he has standing, as long as that is an authentic relationship that we're being shown.
Which we don't need to discuss today, because we could talk about that forever too. Is it? Is it not? It's really strange that she's too incompetent to hire an attorney, but she
gets alone time with.
Yeah, none of these things, add up. So I always am skeptical when it comes to things like that, like super tightly controlled bubble boy, the Truman Show kind of realities. It's like, is this a reality TV show that we're watching? Is this the real world where it is scripted, but it's also not scripted? But it's like, yo, I want you to get in a fight with JT over there because it's going to make for some good footage. and you're like, oh, okay, I got this. Action. Oh, what's up, JT? Just got back from the gym or whatever. Man, F you, man, F you. And then you guys like start fighting. That's like not real, but it is real. So they can call it real. You see what I'm saying?
Yeah, I follow you.
You following me? It's kind of late here, so I may not be making sense. But ultimately speaking, like, I know that that's a question on everybody's mind. Like, what can we do? How can we do it? And like, pressure is the right word. It doesn't have to be aggressive in the sense of
No,
like, here's a death threat if you don't do it. Like, okay, we're not psychopaths, but pressure is literally watching what's going on. It's not stopping the vigilance that's occurring now. It's calling them out for a lightweight accounting, saying, where's the rest of it? It's noticing things that are happening like all the time and making sure that everyone else notices them too, so that it can't just be swept under the rug. Sunshine is the best sanitizer. I mean, you want it out in the light. So that's kind of what we're doing. And, we'll continue to do, but I mean, this is why we talk about these things, because we enjoy talking about these things. And at the end of the day, you never know if you are going to come up with a really good idea that maybe could actually make a difference. The only way to do that would be for us to continue to see what's going on and soundboard out loud. Like, how would you handle this? How would you handle this?
soundboard with ourselves and other people as well, and not, um, discourage people from expressing their thoughts.
That's a really good segue. So I like to pretend to be dramatic sometimes. And trial is theater. So we do that and we do it well. But all in all, we're really not shit starters. We're really not trying to fight with people on the internet. Our entire purpose in doing this is literally to continue to sanitize the process of getting Britney Spears out of this conservatorship. This is what's happening. These are our thoughts. This is our insight. People get nervous when they don't understand things. Like, I'm not a doctor. When I go to the doctor and they're talking to me about certain things that may or may not be happening, I want them to break it down because they're talking in terms that I don't understand. Our clients get nervous all the time. How many times do you have to explain litigation, what the process of filing a lawsuit to completion is to your client? How many times?
Oh, just per like one client?
Yeah.
Every 3 weeks.
Every 3 weeks.
Every time I talk to them, pretty much.
Like, we were literally joking the other day about just making a recording and pushing a button so that they could hear us say the same thing that we already said to them. Like, I mean, and don't get us wrong, like, we're not hating on our clients. It just is a constant reminder that what we do and our job specifically is foreign to anybody who doesn't do it. So this isn't us stepping up to the plate saying, oh, look at us, we're so cool, we're the coolest, we're freaking lawyers. I mean, to be honest with you, it is an awesome job sometimes, and other times it's a terrible job. I have like 1,000 bags under my eyes. I mean, it's a stressful job. We just wanted to make sure that for those of her fans out there who are paying attention, who are part of this movement and who want to see her in the best place she can possibly be, that have questions about, is this normal? Is it normal for them to show up at court and say, oh yeah, we discussed it and we're just going to kick it? Is it normal for accounting paperwork to be 131 pages for somebody whose estate should be worth like $600 million? Is it normal to get motions back and forth that deal with very specific objections and then never see the actual resolution because it was negotiated behind doors? Is it normal for attorneys to be paid at such exorbitant rates for the work that they are doing. And we're just here to offer what we think. People can disagree with us all they want, and that's perfectly fine. We disagree with people every single day.
Kind of a thing.
Like, there are mornings where I wake up and I look at Sam as I'm having my cigarette and Red Bull, and I say, I really don't feel like fighting today. And he says, well, you're really in the wrong business for that. And so we go about our lives. I mean, we can fight. We don't want to fight. And we certainly aren't trying to take a fight to the Free Britney movement. What we're trying to do is offer ourselves and our, understanding and knowledge of legal proceedings to anybody that wants to hear them, and maybe give them some peace of mind, or, let them know, like, we think this is kind of alarming. Like, some things we think are normal, some things we think aren't. And I think that's important for people to be paying attention to. So it is really annoying, I'll use that word, that we have to take time out of this video where we're talking about things that are important to make it clear to everybody out there that yes, we are attorneys. Yes, we do practice. No, we did not just graduate law school. Yes, we have resumes the size of our arms. And we have various skills in various areas that we're very proud of. And we're absolutely from the state of Kentucky, and we would not have it any other way. And for those of you out there who've never been to Louisville, just Google it. There's 1 million people that live in the city. Like,
16th largest city in the country. I mean,
it's not a small town. It's not rural. And even if it was, because I'm proudly from a part of Kentucky that is rural, it doesn't matter. Why does that matter? And why are you drawing attention to it? And why are you trying to pick fights with us every post we make? It really detracts from everything.
You come onto our post. We don't go onto yours. You come onto ours, and you want to say that we're from Kentucky and, imply that the bar exam in Kentucky must be so easy. I mean, I'm sorry, how just out of touch are you? I mean, did you take the bar exam? Because you did. You know that I took the same half of the bar exam that you took, the MBE. It's a standard national test. So that's just really unfortunate that someone would say that if they actually took the bar exam. I don't know.
Yeah, and I
mean,
thought
I
it
do.
was.
She's licensed in New Jersey, but whatever.
Well, I mean, here's the thing. It's like, we are having this discussion now, and we talked earlier about having this discussion because, again, there's just so much drama going back and forth. And we want to make it clear to the people out there who are looking at our Twitter page and following us for actual information. That is what we're here for. But we also are
not going to
not
turn away. We're not going to turn away from that shit.
From that level of insult. And the truth of the matter is, the diminishment of our own careers is very sad. We have exceptional careers that we're very proud of. And in fact, Sam and I, we had our first trial the first year after we passed the bar. It was 8 days long, and we got a $250,000 verdict for our client who was discriminated against based on her race.
Yeah, and I'll also just point out that our first jury trial, we did it on the heels of leaving our first job to start our own law firms.
Literally, we did. So, and we both have various experiences in different backgrounds. We both have some experience in criminal law. Sam worked at the Commonwealth's office here. I worked for the Kentucky Innocence Project, then we both ended up working at the same civil litigation firm. I started working there and talked to Sam about it, and he seemed interested, and there is a huge need for civil rights attorneys everywhere in the country, not just in Louisville. But I definitely saw that this could be something that we made a business out of and invested our lives into, because
and filled the need for. I mean, at this point,
exactly.
we both opened our own law offices, and we're not taking any new clients. We had to cut that off because we have too many, and trust me, we don't take any client that calls us. I mean, it's a process. Um, but we get to a point where we can't take any more clients, and we're still getting calls because there aren't very many civil rights litigators out there. Not in our jurisdiction. I mean, we both have statewide offices, not that I know of in the surrounding states in our region. I think it's pretty much a national shortage that, you know, we try to fill. I mean, in our state, at least.
In our state. And I mean, here's the deal too, just to kind of piggyback on that. There aren't enough civil rights attorneys out there. And I'll tell you why. Because it's very difficult work. Sam and I share ADD, okay? And something that is really good for us, whose minds work extremely fast, sometimes faster than they should, and jumping to conclusions they shouldn't, but is to have some very specific, intricate, intellectually stimulating area to practice in. We have to prove in civil rights cases actual animus. So the inside of someone's mind, how they were thinking when they made decisions about our client's employment status. We don't get an X-ray like a personal injury attorney. We aren't arguing solely about something that's contained within a piece of paper. What we do is arduous. If you notice, I said the case that's going to trial is a 2017 case. That's 4 years old. These cases are monsters, but it's important that somebody do the work and do the work right, and somebody do the work with the right kind of mindset, and that their heart's in it. I had a case.
Yeah, go ahead.
Go ahead.
I would say the heart's in it. I mean, I've talked to you about this a lot. I've received, and I think you have too, multiple clients that they call my office and they say my case started out. The lawsuit was filed. It's been a few months. We exchanged discovery, and I'm looking for a new attorney because my attorney so-and-so, whose name I won't say, but as soon as I hear it, I know why they want to leave. It's because he asked them if they want to be on the settlement list, which is basically his, are you going to take $10,000 for this case list? And let's just check it off. I'll get a check, you get a check, and we'll walk away. And I'm not going to do the full work. I'm not going to get you to the point and to the amount of money that you deserve, because it takes a lot of time. And there are attorneys like that. There's a lot, actually.
There are a lot of attorneys like that.
Settle it for less than what it's worth.
Right. And we always have a saying that we'll never sell ourselves short, and we'll never sell our clients short. And because our compensation is based off of what our clients receive at the end of their claims, except for the rare, defense case that we take, small company case that we take, contract case that we take, we make sure that, we are doing justice by them. It's not about us, and it's not about getting paid. Although we have been paid, and we've been paid very well for what we do, it's really not about the money for either of us. Ultimately, there's a whole other aspect of that. If you care about civil rights litigation, like there are a few lawyers in this town who are incredible, and I don't care to mention Robin Smith by name because she's a rock star who has been an excellent mentor to me and Sam, and always seems to jump in right at the moment that she has a piece of information that is, critical or vital that we didn't even know existed. She's excellent with timing, but she has talked to us on many occasions about how important it is in this particular area of the law for us to be thinking about our clients, but also to be thinking about developing the law to help everybody So nobody ends up in the same situations as some of our clients. One case she helped me with, my client passed away while litigation was ongoing, and her brother decided to step in on her behalf and finish this lawsuit, which he didn't have to do, but he did to honor her memory because she was very mistreated and terminated for her age and her disabilities. Ultimately speaking, this case was dismissed at summary judgment level. So that's before you get to trial. It's the last thing you do before trial. And it's a 2016 case. So it was dismissed, I think, in 2017. And I had to think really long and hard about whether or not I was going to appeal this case. I didn't want to drag her family through any excess litigation. They're suffering a huge loss, and litigation can be very stressful. But I also was not willing to accept that my client, who's no longer here, would not be able to ultimately get the justice that she deserved. So I did appeal it. And I appealed it on several bases. And we got called for oral arguments in October of 19. I mean, we appeal cases all the time, but oral arguments are different. It's not every day. It's on new issues of law. And in this particular case was about people, employees signing these waivers for companies that they work for, particularly a large hospital employer here in Louisville and all of Kentucky, really. They sign these waivers that say they agree to file lawsuits, essentially, within a 6-month period of time of the last Adverse Employment Act, up into including termination. It's very legally intricate, but ultimately speaking, I made 3 different arguments, 3 different bases. While my appeal brief was pending, everything had been briefed. Congress came out and passed a law.
Yeah.
And they kind of took care of the problem. So then what we were fighting about was whether or not this law should be retroactive. So we get to the Court of Appeals and, oh my God, you should have seen the guy on the other side. He was like, he was in a losing battle from the second he stepped in there. I had a good feeling that we were going to win on the basis of this new statute. What I didn't know the court was going to do was actually make a ruling about the arguments I made, specifically about what constitutes adverse employment. Is it possible to be post-termination, continuing violations? And they did. It's brand new law. Published opinion, brand new law, impacts everybody in the state of Kentucky, not just my client. And now we just set a trial date for that case today, this morning, actually. So, we do a lot of things that are really cool and really important. And that's what led us to Brittany's specific situation. Not to mention, Sam is probably the biggest super fan I've ever met. And that's not to throw it, out there as bad, because don't get me wrong, I'm a big fan myself. Anything that you want to add to that? I guess the point is that we're trying to make is that we do a lot of things. They're really cool. We care about our clients. We're proud of what we've accomplished. We're proud of the state we live in. We're not here for drama. Let's just shut it down now, okay? Because seriously.
Can we just do a little bit real quick though, because you mentioned Robin, which kind of got my mind thinking. You remember that jury trial we went and watched that she did?
Before we knew her.
Yeah, and who she was suing?
Yeah.
Basically a sweatshop for attorneys.
Yeah.
So this account and the one attorney that is associated with that account, Lawyers for Brittany, that's what I'm talking about, wanted to make light of the state we live in. And I think they've recently said that we are new attorneys, which isn't true at all. It's just funny because you mentioned Robin. People that she was suing, the company, it was a sweatshop for attorneys, which is where, Kristen, you work, actually. You work for a sweatshop, an attorney sweatshop. So I'm sorry, you went there straight out of law school, from what I can see, after you passed the New Jersey bar. Don't, maybe don't pass judgment on other people's decisions and say that we started a law firm right out of law school, because we didn't. We had other jobs before that as attorneys, and then we had enough money to start up and to open up our own law firm because we were successful, and we're successful to this day.
Yeah,
So you
that's
can
the
have fun at your
reason.
sweatshop, but stay off our timeline.
That was really awesome and aggressive. I'm here for it, every second of it. Thank you for channeling that. I would probably say that to her face if she was
Wish I
standing
could.
right here. But ultimately speaking, it's just kind of embarrassing for her, to be perfectly honest with you. Nobody was trying to start a fight with you. We're all allowed to have different opinions. I honestly don't understand why this is where you want to spend your time. And the truth of the matter is, as Sam stated, the only reason you leave a law firm that you work for is because you're making them so much more money
This should be going in your pocket.
that should be going in your pocket if you're capable of handling it, handling employees and overhead
I'm paying them.
and paying
I
all
pay
of your bills.
out
And
of my
then,
pocket employees.
I mean, it's like, you can't degrade our experiences. We earned what we have and we're proud of it. $26 an hour is really
But here's-
sad.
but
Like,
she doesn't even pay.
well, here's my thing, is like, she made a comment about I can buy them for $26 an hour. Well, I'm sorry, but if you're paying somebody who went to law school $26 an hour, you're an asshole.
What are you getting? What type of product are you getting for
What
that?
type of product are you
Because
getting? And
that's about what I pay my bottom level employees, like law clerks and legal assistants.
I mean, and my point is that most people who go to law school come out with student debt. I mean, you can't live off of $26 an hour in freaking South Florida or wherever you live. So, I mean, you're basically like paying the equivalent of minimum wage. And if you're doing so well in that business, then you should be sharing that wealth with your employees. So that wasn't actually insulting for us because we know where we are and what we're doing with our lives. What really pisses me off is that you, again, are detracting from what's important and forcing us to have this conversation. Like, I don't want to have this conversation with you. Like, I don't even know you. I don't want to know you. And based off of all the things that you post and the fights that you pick and the people that support you who pick fights on your behalf, like, I never want to know you. So stop making it about you and make it about what it's supposed to be about, Brittany, and stop hating on people's opinions about
Or
whether or
just
not
trying
this
to
is
find something wrong with them.
right.
It's like, oh, what can we see? What can we find that's wrong about this?
And here's the thing, if you're going to defend all these freaking pro-conservators, if you're going to defend, Jamie, and you're going to defend the process, and you're going to defend Jody Montgomery, and you're going to defend the fact that Brittany's in this conservatorship at all, then just do it, own it, and be done with it. Don't go around to people who don't feel the same way you do with all of your experience in civil rights litigation and try to poke fun or degrade. It's really pathetic. I mean, and I am mad that we took time out of a video that could have been more informative to just talk about ourselves, to make ourselves feel better. No, I'm just kidding. We feel pretty good all the time, but to make a point, like, hey, we're here. If you want to talk to us, feel free. Feel free,
Yeah,
get in line.
Get on a video. We'll talk to you face to face.
Yeah.
Not afraid of that at all.
Not at all.
What encouraged you to maybe go back and re-examine some of the language you use in your text? When I see things like unhinged, obsessed, crazy, those are the words that cause a lot of harm to Britney Spears in 2007. Those are the words that were in the tabloids and on, the gossip blogs that were weaponized against her, and you're using them now. So maybe don't do that.
And talking about where people are from as if that defines them in any way other than excellent. You can be awesome and be from Alabama. You can be awesome and be from Kentucky. You can be incredible and be from Louisiana. Like, you don't have to be Mormon to live in Utah. Like, everybody is not defined by stereotypes that are associated with their state. So what was the point of that? Except to be ugly. All you're trying to do is be ugly.
Nasty.
Like, you're in a job where if you're a litigator, you're fighting every day. So why the hell are you bringing that shit to the movement at all? Nobody wants to fight with you. We maybe seem like we do now, but we really don't. We don't, because I'm closing the book for you. Oh, Casey.
I blocked all of them. So yeah, we're done until if someone else comes on our timeline. I'm not gonna say they're gonna make offense to us and come at us, but if that happens, then I guess we'll be back at it. But hopefully they leave us alone and we'll leave them alone.
Well, yeah, and the thing is like, let me be very clear. We're not pro censorship at all, period. But I'm sorry, you're not trying to have a dialogue. It's okay for you to have a different opinion, even though I may secretly deep down inside think that your opinion is absolutely stupid and makes no sense at all, and clearly doesn't have the best interests of certain individuals in mind. But you're entitled to that opinion. If you want to have a dialogue about it, have a dialogue. If you went to law school, you should know how to debate. You should feel confident in your ability to argue your points. You should feel like the facts are on your side, Casey, and be done. And by Casey, I'm doing K.C. Okay? Not Casey. Although there is a really famous Casey from Florida, not for a good reason. Sam?
I think we covered it.
Did we do it?
Yeah.
Okay. Well, I hope this wasn't too long, too boring, or too rambly. If you guys have any other questions, you know where to find us, post, etc. Maybe we'll do a more or less, rather, passion-driven video later this week.
This week, not tonight.
Yeah, not tonight, obviously. Okay, good night.
Bye, guys.